now take up a special contract called the contract of agency, uh, which I think is very relevant and important, considering the fact that there are numerous sections in the Indian contract, right, that deals with the rights and duties of an agent, and understanding the same in the context of the fact that there are a lot of contracts in which agency gets created. Understanding this chapter becomes relevant and important because mostly we see agency being created out of an extension of an employment contract. So to understand agency, friends, let us start by asking ourselves, how is agency different from, say, employment, or what we call as the employer-employee relationship, or what you may also want to call as the master-servant relationship. Now, you will notice that a servant can definitely become an agent, but an agent is never a servant. Right? Now, you create agency because you find yourself not to be in the place where the contract is to be made, and hence you want someone to do the contract for yourself. So you will find agency contracts being created on numerous instances and occasions. And one of the oldest forms of agency is an auctioneer, who auctions your property, be it mobile or immovable property. An auctioneer is a typical agent who is assigned with the task of actually selling someone's property. Today you find auction houses, say in the UK, which are also selling arts, cultural items, or even painting for that matter. So they are specialized agents. Now what they do is, auctioneers, they don't work for a single master. They work for several people. They are quite independent in what they do, and hence you call them as agents rather than servants. Servants are full-time employees. They are supposed to be loyal to their employers and they get a salary. Whereas agents are independent, they are discretionary in nature. They can work for several people, and usually they get paid based on their commission that is agreed upon between the two parties. However, one thing that is very common in understanding servant and agent is the fact that both servant and agent can bind their master, or what we call in agency as the principal. And that is where the principle of vicarious liability, a principle where the servant or the agent, when they do any act, they can actually bind their master or their principal, because whatever they did, they were doing so for or on behalf of their master or principal. And hence, one of the most interesting tests of vicarious liability that you can apply in a master-servant as well as a principal-agency relationship is this. First and the foremost, please understand that the master is liable for all the acts of the servant vicariously if it was done within the scope of employment. So the test is, if the servant has done any act within the scope of employment, he can bind the master. Both of them will be jointly responsible. The master is going to be more responsible for the simple reason is that because he has deep pockets. This was done by the servant for the master during the course of employment, and hence the master who finally gets benefit of this act should also be liable for the same. Whereas when it comes to agency, you will notice that the principal can be held responsible for the acts of the agent if it was done within the scope of authority. Because the agent will be given some kind of an authority to act on behalf of the principal. If the agent does any act within that scope of authority, he can bind the principal, because finally the principal was going to get the benefits of the agent's act. He should also be held responsible or liable for any of the acts of the agent towards the third party. So that is where the principle of vicarious liability will be applied. But interestingly, please note, in agency we apply the test of what we call as within the scope of authority. So agents get authority like an auctioneer, and if he acts within the scope of the authority, anything that he does, I think the principal will be bound and responsible for the same. Interestingly, when you talk about agency, friends, you will notice that today a lot of people want agency to be created. We can talk about numerous examples where probably a celebrity or a film star or a film actor wants an agent, and he appoints one. Now, what do the agents of these celebrities or film stars do? They usually try and get them certain endorsements. They can get them public appearances. They take care of their external work, and also probably get them movie or film assignments. These are the ones who will negotiate the price, the days, and all other contractual deals for the celebrity. And that's why you will notice that most of these celebrities go by their agents. Interestingly, even sportsmen require agents because that is where agents help sportsmen earn beyond what they are, doing in the sport. And these agents actually represent the sportsmen with all their external transactions, including advertisements or appearances, getting sponsorship, trying to sponsor their training or any of their aspirations that a sportsman has. So you will see agency or agents being employed in several of these businesses, and it's a very common factor, and hence this chapter on agency becomes very, very relevant at this context. Not only that, if you talk about the real estate law in India, today you will notice that real estate is usually dominated by agents. And the RERA Act, the Real Estate Act of 2016, mandates under Section 9 and 10 that agents must register with the RERA authority. And only when you register, you can actually act as a broker or an agent for these real estate companies or for their clients. And that is where agency under RERA is also a regulated activity. So you call them brokers, but that is what land and property dealers do. And that is what agency also matters in those contexts. You will find agency even in the insurance sector, which is very, very popular right now, with what we have the regulator called the IRDA, that is the insurance regulator that we always say, Insurance Regulatory Development Authority, IRDA. You will notice that agents have to register with IRDA, and only then they can actually sell insurance policies or insurance products. Now, what do these agents do, friends? You will notice that in the insurance sector, the agents represent the insurance company. They get business to the insurance company. And once they get these insurance businesses or policies, they get commission based on the insurance policies that they sell. However, you should also note that in some of these contexts, agents also represent the customer. It's like, representing both the buyer or the seller or the insurance company and the policy holder as well. So they represent both these two parties, and that's what agents can actually normally do. So the insurance business also runs through agents, and they actually propel the business. And they're trained, they get a license, they're registered, but that's how the insurance business has largely functioned due to agents as well. The oldest life insurance in India, called Life Insurance Corporation of India, had agents who actually have enhanced the business of the Life Insurance Corporation of India. Now, having said all of these, friends, you will notice that where can you see agency? You can see it in patent law as well. Now, when you file a patent, you need a patent agent to file it, and the patent law also allows for patent agents to register and practice before the patent controller. And it is definitely possible that suppose someone wants to seek a patent, he goes to the patent agent, because the agent would then know the process and the procedure to actually get and secure the patent. And when they do so, then obviously that is how they appear before the court of law, before the patent controller. Now, having spoken about the court of law, the interesting question then comes is whether lawyers or advocates are agents. Now, there is nothing that prohibits lawyers from acting as agents. They can definitely do so. But you should also notice that when an advocate gets his client to sign a vakalatnama, it's kind of a representation, because the law of agency is also called the law of representation. Rather, it is called representative contract. The agent is there to represent the principal. The lawyer is there to represent the client in the court of law. And hence the vakalatnama becomes a kind of a document where that representation of the authority is vested in the advocate to represent your case before the court of law. But having said that, you should also notice that advocates are not only representing their clients, but under the Advocate Act of 1961, they are also called as the officers of the court. So they are officers of the court apart from representing their clients. So they are duty bound to, not mislead the court, to follow the rules and regulations of the court, and to maintain the decorum of the court as they go by. But that's how probably you look at it from an agency perspective. But remember, advocates are not making a contract for you. They're just trying to exercise your rights before the court of law or make your submissions before the court of law. Normally, what do agents do? they will make a contract for you. They will actually bring the third party and see that you and the third party actually create a contract. That's what normally agents are supposed to do. Advocates generally don't do that, but lawyers can definitely do these kinds of transactions. So an advocate is a registered member of the bar. A lawyer is one who practices law apart from what the court practice is all about. Also, at this point of time, it's very important for us to understand that as soon as the Contract Act was made in 1882, the Britishers passed a very interesting and important legislation called the Power of Attorney Act. That is a very important law in the sense that it creates agency and its documentation that is required in a formal mechanism called the power of attorney. So authority is vested in the power that you have given to an attorney, right? That is how the Power of Attorney Act is actually being viewed and enacted with. Now, if you look at the Power of Attorney Act in India, friends, it's an instrument, it's a legal instrument, it's a valid instrument, it's a evidence-based led instrument of creation of agency. And in most cases, the power of attorney is very, very important because it gives a legal authority to someone to act on your behalf, right? So you can either execute a simple power of attorney or you can execute what we call as the general power of attorney. Now, GPA, as it is known in the common context, becomes a very, very important document for all practical purposes. And you have Supreme Court judgments that have decided in what cases GPA can be issued and in what cases you cannot issue it. There is a very landmark judgment of the Supreme Court called the Suraj Lamps case. Now, general power of attorney, friends, is normally granted where you probably give sweeping or very wide powers to a person to represent on your behalf. Where do you see general power of attorney? I think you see it in commercial transactions, you see it in personal transactions as well. Where do you see in commercial transactions, friends? You will see that when joint development agreements are made between the landowner and the builder, right? This is what is called JDA. The landowner, apart from doing this joint development agreement with the builder, also has to give a general power of attorney to the builder so that the builder can actually go and seek permission from various government departments to start the construction and the building and get the approvals so that the building can be completed and then later on it can be sold to the third parties or the customers. So GPA in commercial transaction is viewed that way. You will also notice that a lot of non-resident Indians or non-resident businesses may require GPAs to be executed because they are not in this country, so they cannot be there to do all transactions. For example, an NRI who has a house and which is giving rent may give a GPA to one of his cousins or relatives or a friend and say, look, you can go and collect rent, right? Apart from collecting rent, if you want to give it to a new tenant, you can also do it. If you need some to repaint the house, you can also go and do it. You can spend from that rent collection. You can deposit this rent in a particular bank. And those are some of the circumstances in which general power of attorney is also extended or issued in a personal capacity as well. So it's a normal document very often than not that is issued as an agency that is being created under the Power of Attorney Act. This act talks about revocation of the GPA. That's definitely possible. It also provides for registration of the GPA because then it becomes a very serious document. It cannot be cancelled unless you cancel the registration as well. So that's all how things apply in most circumstances. And agency then becomes a very critical factor in the day-to-day normal transaction. Friends, what is important at this point of time is to talk about two very important and interesting kinds of agents. First and the foremost, we have to talk about partners as agents. Friends, under the Partnership Act of 1932 as well as the LLP Act of 2008, which is the new partnership law, because in India we have two partnership laws, 1932 British made law, 2008 Indian law on partnership, which talks about limited liability. 1932 is unlimited liability. But if you read section 18 of the 1932 Act, it very clearly states that there is this concept of what we know as mutual agents under the partnership law. Now, the concept of mutual agent is interesting because, please note, under the 1932 law, the partnership firm does not have a separate legal identity. That's what we ordinarily believe in. Though you can have your name is different and your firm name is different, you can actually go and register a business name for the firm. But it's not considered as a legal person in the eye of law. So the partner's identity is the firm's identity, right? That's the normal technicality under the Partnership Act of 1932. So the firm does not have perpetual succession. If the partners die, the firm also dies. In that sense, right? So that's the reason it does not have a separate legal existence. And you will notice that suppose I and you are partners, you can represent the firm, but when you represent the firm, you're also representing me, right? This is mutual agency. So I can also go ahead and represent the firm, but when I do that, I also represent you. So the concept of mutual agency clearly states that partners can equally take part in the business of the firm. They can represent the firm as per the partnership deed, whatever is the powers or authority that is granted to them. And when they do that, because the firm does not look to be a separate legal person, you are actually representing the other partners. So that's how the concept of mutual agency applies, and the principles of agency may also apply to such transactions where the partners act on each other's behalf. The second most important type or aspect of agency that we must cover is directors of a company as being agents of the company. Now, you know, friends, that a company cannot act on its own because it's a legal person, it's a juristic person, and it requires natural person to act on behalf of the company. So, company needs eyes, ears, and a person to actually act on its behalf. So the managing director or directors are supposed to be those kinds of agents. Now, when we say directors are agents of the company, please note they're representing the company with outsiders for outside transactions. They have to enter into contract, they have to look into employment, they have to look at procurement. So who acts on behalf of the company? It's the directors who act on behalf of the company. Right? So the board of directors is a collective body. Directors are in their individual capacity. Wherever there's such authorities vested by the articles of association, they have to act on behalf of the company and represent the company as well. Not only that, you will notice that when you talk about directors, there are different kind of directors. We say executive directors who have executive functions, and then we have independent directors who may not have executive functions, so they may not have that representative character. They may not represent the company, though they can take part in the meeting of the board of directors. They can actually monitor, supervise, but they cannot represent the company. So I think the role of partners and directors who can be agents and who can act as agent becomes very, very critical and important, because you can only look at that from, say, the partnership deed or the articles of association, which is the registration document for both the partnership and for the company. Now, you will also notice that in partnership, we also have a concept called sleeping partners, which means the partners does not take part in the day-to-day operations or activities of the firm. He just makes a capital investment or lends some kind of a name. So he is not supposed to have authority to represent the firm, like independent directors also may not have such kind of an authority. And that's how probably one must understand the kind of operation of agency that you see in a very broad context, and the importance of the law on agency as well. Finally, I think just to give you the contextualization of agency, you will notice that when we discussed about pledge, when we discussed about bail, please note the bailee and the pawnee at some point of time may act as an agent. That is when the bailee, while exercising his right of lien, because he has not been paid for the goods from the bailer, suppose he has done some service of labor and skill and it's not been paid by the bailee can exercise right of lien. And once he exercises the right of lien, then he may want to exercise sale, right? Because he has to recover that kind of labor or skill. So when you exercise the right of sale, and when the pawnee also decides to sell the security of the pawned goods, because you have not repaid the loan back as the pawner, then in those circumstances you will notice that they may act as your agents, right? Because they don't have the authority. It's not their ownership. They are exercising the right given under law, and they are exercising the sale. They may probably be doing the sale on your behalf as agents, right? So the principles of agency even may apply to those kinds of special contracts or transactions as the case may be. So you will find agency as a very important business proposition in many circumstances in our day-to-day activity. The last point here is to also understand agency in the international context. Because you will notice that a lot of these, trading houses or warehouses, or even a captain of a ship or a carrier may be an agent, right? Including, say, an air carrier, a sea carrier, or a road carrier. They also can be agents because they may actually be dealing the goods on your behalf at some point of time. The best example is, suppose there is a road carrier who is carrying tomatoes, and due to a strike, he is not able to reach the destination. The tomatoes are actually deteriorating, and the lorry driver then decides to sell the tomato. Right? He is a transporter. When he is a transporter, you are a bailee. But at that point of time, because to save the goods from deterioration, he has to make a sale. When he makes the sale, probably he sells it on your behalf, and that is where the principles of agency may come into place. Coming on to understanding how agency can be created, we obviously think that it is a contract, and contract, as we know, can either be implied or expressed. Of course, modern forms of agency are definitely expressed contracts, but if you look at the traditional jurisprudence on agency, you will notice that agency can be created out of the conduct of parties, and one of them is by the rule of estoppel, which is a kind of a rule of evidence that we have seen under Section 115 of the Indian Evidence Act. So, estoppel or holding out, you will notice, friends, are one way in which agency gets created when someone who I have held acts as my agent in the past, and he continues to do so with you in the future. But there is no implied or express authority, but just by the conduct of parties of holding someone as your agent, he may continue to be so in the future as well. So, under the principal rules of estoppel, you, as the principal, will be stopped from denying the truth that in the past he had acted as your agent. So, in this current transaction as well, because there is an agency that has been created, you may be bound by his actions. So, that's how probably agency becomes important, because very often than not, you will notice, friends, that every other aspect of agency cannot be defined. Every other authority of an agent cannot be expressed, and hence you may have to structure or create an agency in certain situations and scenarios. For example, can you have agency by necessity or urgency, or the fact that the principal cannot be contacted or is not there? You have to act on his behalf, right? So it may not be with any kind of an authority, or it could be an extension of that kind of an authority. So can you then infer agency by necessity, right? So this is also important in the context of the fact that if you look at custom and trade or usages, sometimes the principal may not be available to seek his permission, and the agent then has to act out of that necessity. One common example that is often given is the captain of a ship trying to offload goods from a ship when there is rough weather. To save the ship and to save others' goods, he actually offloads the goods or throws it into the sea, and he may not be in a position to actually contact the principal in those circumstances. Also, you will notice that you can create agency by operation of law, in the sense that though it's not contractual, but it is by status that agency gets created. Now, to understand agency in terms of operation of law, or by what we call as status, one would understand that the karta of a family is an agent of that joint Hindu family, right? So the karta is the head of the family, and in a joint Hindu undivided family, the karta actually acts on behalf of the co-parsonaries. He acts on behalf of the family members. Because he's heading the family, he has the agency to represent the family with third parties, make transactions, make sale, make buy, and he's given that express authority by the status of operation of personal law. Extending that operation of personal law, you will notice one of the interesting characteristics that one sees is how a wife can actually represent the husband, or the husband representing the wife, as the case may be in marriage. Now, you will notice that most spouses have the right to represent the other for necessaries of life. Now, necessaries of life means food, clothing, and shelter. Now, the wife probably cannot get an express authority from the husband. If it's expressed, it could be a GPA. Of course, third parties through a GPA then can make a sale and bind the husband. But the husband may be on the ship, he may be an NRI, he may not be in town, So the wives or the spouses should have that kind of a agency, that when they procure these necessaries of life, they are procuring it for the family, and the husband or the wife is going to be bound by the same. So that is how by status agency gets created, even in a domestic family circumstances, right? Now, the operation of law scenario can also be created out of, say, things like where government contracts are going to be made. You will notice that Article 299 of the Constitution of India brings in a law wherein it says that the executive power of the state is with the President of India and the governor of the state, as the case may be. So contracts are executive functions, and the government of India has to be represented by the executive organization of this government, because government can be divided as the legislative organ, the executive organ, and the judiciary. And the executive organ is the executive function of contracting that is vested in the president or the governor, as the case may be. That's what the Constitution, by operation of law, vests that kind of an authority on the President of India. But you will notice that under Article 299, while the President and the Governor have these powers, there is a provision where the contract can be made on their behalf or maybe under their authority. So that is how the delegation comes to the Council of Ministers, the Prime Minister, the departments, the secretaries, and so on and so forth. So that is the kind of delegation that is generally made so that others in the government can also exercise powers on behalf of the Government of India. Also, one should understand that agency is important because you have to locate whether you have the power, you have an agency, or you have something else. For example, we say an agency is different from the kind of trust that trust creates or the trusteeship creates. Now, generally, if trust is created, you obviously may register the trust as a charitable trust or as a public trust or as a private trust as well. And the trustee has to act on behalf of the beneficiary, right? But the trusteeship is a different doctrine, though, sometimes we will say that the trust has acted on behalf of the beneficiary, which means the trustee is an agent of the beneficiary. But the point is that trusteeship is created to manage the property for the beneficiary, but not the beneficiary being, appointing the trustee. So again, you will notice that some kind of a principle of agency by operation of law gets created in trust property, and the trustee then acts under law for the beneficiary, but as something that has not been directly appointed by the beneficiary, but in terms of the trust property as well. So generally that's how you will want to see agency, and you will notice that if you look at the law, even a minor can be an agent. Anyone under the law can be an agent. However, if a minor is appointed as an agent, he is only appointed for the benefits of agency, and he cannot be held responsible personally, individually, because that's the protection that is given to minors. Also, you will notice that the principal has to be of sound mind. He has to be a major. The principal can be a natural person or a legal person. That's not a problem. And you can appoint agents even beyond the territories of India. But you can see the enforceability of the contract in India. So that's something precisely where you would want to locate and see how agency operates. Also, the final aspect is by agency by ratification. Now, agency by ratification, friends, ratification, the term means very important, and I think this part assumes a great amount of significance in the practical sense of the term, because to ratify means to give antecedent authority. To ratify means to affirm what was done in the past when there was no authority at all. To ratify means to give retrospective actions a prospective effect. So, can agency be created by ratification? The answer is absolutely yes. That's what the chapter on agency does say. So, let's assume that you have acted on my behalf, right? And you have sold my car, right? But I had not asked you to do it. I had not authorized you to do it, but you did it out of good faith. Now, I think the deal is good. I think the deal is fine. You acted in good faith for my benefit. Now I can say by ratification that what you did is something that I approve, I affirm, and I will accept the payment, and I will transfer the title to that third party. This is how agency by ratification can come into place. Now, very often than not, why ratification is important is because every time agent's authority cannot be defined or laid down, and hence, out of necessity, out of good faith, out of actions for the principal, the agent may act beyond his authority. It is for the principal to have the discretionary power to either ratify or not to ratify. But if he ratifies, please note he has to ratify the whole transaction. He cannot pick and choose. If he ratifies, he will affirm and be vicariously liable. If he ratifies, he must do so with full knowledge. And once he does that ratification, an agency gets created, and the act of the agent then becomes a valid action of representative character. So this is also relevant and important in government contracts sometimes, because we say, sometimes when government officers act and the government agrees to the same, it's a process of ratification that the government has done. So, right. However, in government contracts, you will notice the rules are slightly different, because constitution, public policy, public interest, and public welfare are involved. And in those circumstances, you will notice that unauthorized acts to be ratified, I think the government has certain rules that need to be followed. That's something that principles of constitution and administrative law will definitely come into effect. However, in public sector organizations and companies that are government companies, ratification is a process where a director has acted on behalf of the company, though he had no powers to do it, though he was not authorized to do it. Then the company in the board of directors meeting says, fine, whatever the director has done on behalf of the company. It's good for the company. We have affirmed it, and hence we can go forward with the same. So usually when directors enter into contract, or they place certain orders, or they have probably even fired an employee, or hired an employee, or they've acted with some third parties without any express authority, the principles of ratification can definitely come into place, and the principal has an option or a discretion to ratify that action. So that's how agency by ratification becomes critical. It becomes very, very important aspect of creation of an agency, and it binds the principal once ratification is completed. And it's also one element of where contracts can have a lot of uptake. For example, there needs to be an amendment to a contract, say a government contract, which is a long-term contract, it's a works contract, it's 3 years, 5 years, EPC contracts, and so on and so forth. And the officer of the government has agreed to the amendment, right? Though, any kind of amendment should be done by the competent authority, but the officer who was in charge of the contract management agrees to the amendment because he thinks it is necessary. He thinks that is the best way forward, and he has kept government interest in mind. Then those cases, the competent authority can definitely ratify the actions of the officer who was in charge, right? So ratification in administrative law is important. Ratification in contract is also very, very critical, and that is the process in which agency gets established. And I think it's very important for people to understand this process, because unless you have done a complete ratification with complete knowledge, the ratification may not be valid. It's a choice that you can do so, but you should do the choice of election in terms of ratification as soon as possible within a reasonable time, and this will make the principal bound to the actions of the agent. Now, please note, if the ratification is sought by fraud or misrepresentation, then the ratification becomes invalid. If the ratification is sought by misinformation, then the ratification may be invalid. So it is the principal who has to be very careful in exercising that kind of right of ratification, because it will hold him liable and responsible, or it will make that kind of a contract binding towards the third party. Obviously, the rule of good faith applies, that all the parties who are involved in this transaction of ratification must have acted in good faith, including the third party. Because if the third party knew that the agent did not have authority and still goes by it, then he probably has not done so in good faith, because he should have told the agent, please contact your principal, get the authority, only then let's enter into this kind of a transaction. So that's how agency by ratification gets created. Finally, if we should look at, say, from a GPA perspective, general power of attorney perspective, please note, everything cannot be laid down in a document or an instrument called the GPA. Sometimes the agent may act because the principal is not in the country. For example, he may file eviction notice to a tenant, right? You are collecting rent from a house, and you file an eviction notice, you actually sue the tenant, you take a police complaint, and so on and so forth. So, agents can do so many things that are necessary to protect the interest of the principal, and thereby then, when these kinds of legal actions are taken, the principal obviously has to ratify, because all of them were done on your behalf, for your benefit, and for your elections. So in some cases, ratification may be compelled. In other cases, it can be a choice. Also, do not forget that ratification is compelled when the principal accepts the benefit of the act, right? And on the principle of unjust enrichment, you will be bound to ratify. Let me give an instance or an example. For example, I have no authority, and I place an order for 10 laptops. without any authority of my boss or my institution. But in good faith, I think these laptops are very essential because say elections are coming, I'm the election officer, and these laptops are important for tabulation and so on and so forth. I go and place an order, and these laptops come, and my government department accepts the laptop and starts operating the same. Now the question is, when the payment is to be released, the finance department or the accounts raise a flag whether this guy did have the authority to place for 10 laptops because he's a small officer. He's one. He should have taken proper consent. He should have passed the files. He should have got the tender, and he should have got competitive process, so on and so forth. So they raise a lot of objections. Auditors also raise a lot of objections and queries, and then the issue is whether the third party should be paid for it or not. In those circumstances, you will notice that the third parties act in good faith, and the agency or the department accepting the order of the agent becomes very critical because unjust enrichment has already happened. The affirmation by conduct has already taken place because the government department has already started using the laptop, and in those cases, it will be something kind of ratification that the government ought to do. You do not have a choice. You will probably have to, or you will be compelled to actually exercise the option of ratification.